Ladies and gents, welcome back. It has been over a year since the federal government invoked the never-before-used Emergencies Act, the predecessor of the War Measures Act, which was brought about because of the abuses of the War Measures Act by, you guessed it, dear old daddy of Justin Trudeau, Pierre Elliott Trudeau. Now, it's been said that he has abused these powers once again. Now, there was an inquiry into the use of the Emergencies Act, but that process had no teeth. Now we're seeing some actual legal challenges. We have here from the Canadian Frontline Nurses. Canadian Frontline Nurses are the first to bring a federal government to court for putting up the Emergencies Act. The federal court hearing starts Monday. If you're interested, view the proceedings. This is what you must do. Go to this website. Well, there are other ways of going about this. You can go to this website. I'll leave a link in the description down below so you can get in there. But we have more ways of keeping track of this. Now, the CTV News has an article about it, and we'll get to that in 1 second. This is Karen on Twitter commenting on it. The Liberal government wasn't justified in using of the Emergencies Act last year. Look no further than France on fire right now. There's protest of millions of people there at this moment. And a government who still hasn't invoked any sort of Emergencies Act against its own people. Canadians should have the right to say hell no when we disagree. This is absolutely correct. Now, we have here the article from CTV News. No legal justification for use of Emergencies Act, Civil Liberties Group tells court. Ottawa, a national civil liberties group, told a federal judge Monday the federal government is not clearly spelled out proper legal justification for its use of the Emergencies Act last year in response to protests in the national capital and at key border points. The Canadian Civil Liberties Association was among the groups and individuals in the federal court to argue Ottawa lacked sound statutory grounds to invoke the emergencies measures. Now, remember, we did have the inquiry into the use of the Emergencies Act from dear old Uncle Rouleau here. And, well, he deemed it at the end of his findings were that it was not by the letter of the law that justified it. It was justified by his feeling that the government was too incompetent to deal with the situation. So he said, I think, dear old family friend did the right thing. And, well, thank God it had no teeth, because here we are now, and they're actually taking them to court, and this may be a little bit more legally binding here. The government contends the measures taken to deal with the pan-Canadian emergency situation were targeted, proportional, time-limited, and compliant with the Canadian Charter of Rights and Freedoms. Well, if it was compliant, you wouldn't need to suspend the Charter of Rights and Freedoms by using the Emergencies Act. And not only this isn't actually justification for it. This is just an excuse for what they used. This is where it is. Now, we can go over to the Canadian Constitution Foundation's website where they wrote about this here. Legal challenge to Emergencies Act hearing being heard in Ottawa court April 3rd through 5th. So this will be done this week. That's amazing. Ottawa, the Canadian Constitution Foundation, or CCF, is appearing in court April 3rd through 5th in the judicial review of the federal government's use of the Emergencies Act. This judicial review by a court is separate from and not bound by the findings of the Public Order Emergency Commission, or the Emergencies Act inquiry, as we also know it. And unlike that public inquiry, the court will make a formal legal finding on the question of whether using the Emergencies Act was justified. The Trudeau government's use of the extraordinary law may be the most severe example of overreach and violations of civil liberties that was seen during the pandemic, said CCF litigation director Christine Van Geyn. The use of this powerful law was unauthorized because the legal threshold to use the law was not met. The Emergencies Act contains a last resort clause. It can only be used when there is a national emergency and there is no other laws at the federal, provincial, and or municipal levels which can address the situation. Parliament cannot use this Emergencies Act as a tool of convenience, which is what Rouleau justified it as a tool of convenience. There is actually statutory obligations. They have to follow the law, and well, this is what's being argued here. The federal court will be hearing the judicial review on April 3rd, 4th, and 5th at the downtown Ottawa location. Members of the public can observe the hearing online by registering with the federal court here. And again, links will always be in the description down below. Canada's past teaches us that emergency powers should never be used except as a last resort. And indeed, being a power of last resort is built into the language and threshold of the Act. Review, though, the courts is now the last remaining guardrail of accountability, concluded Van Geyn. Absolutely true. Absolutely true. This is really the whole point of them writing the Emergencies Act was because of the abuses of the War Measures Act. So they wrote it and it was supposed to be more stringent. There was very, very strict criteria for which they could use the act, but they went above and beyond that. And well, let's thank God that there are these hearings, and there's the ability to challenge it in court. Now you can follow Christine Van Geyn, again, links in the description down below, on Twitter. She's got a mega thread on Emergencies Act hearing. The hearing of the challenge to the federal government use of the Emergencies Act is about to begin. Check out this thread for live updates, and you can really follow what's going on. Or you can tune into the CCF on YouTube. Christine has given a 1 hour summary of what's been going on for the first day. So I look forward to hearing more from Christine. Hopefully, if we can at all, get her on the channel to talk to this audience here. Message her on Twitter. I've tried. Get the message out and say we would love to have you over here, Christine. Much respect. Also have Eva Chipiuk, friend of the channel and lawyer extraordinaire. In this case, she was involved in the Emergency Act inquiry itself, most famously known for her cross-examination of Justin Trudeau. Tune in to hear the federal court application regarding the justification of the Emergencies Act. So far, the government lawyer, the Crown, is arguing two preliminary motions. One is mootness. They're saying that, well, it's not. We're not declaring the emergency now, so it's moot. We don't have to discuss this. That is not. That is the issue. The issue is not live, so the court should not hear it. That's a ridiculous one. Standing. She's saying the court's saying that they don't have standing. That the people that filed the application don't have standing or the ability to argue this issue. Well, let's hope that it seems like that didn't go through. Anyway, there's a big long thread here from Eva Chipiuk. You can go through this as well. Again, links in the description. Good point by the Applications Council that the part of the reason used to justify the invocation was reputational harm to Canada. So this is, again, more excuses. These aren't the actual criteria of the law, and this is why you have these court challenges and not a public inquiry like we had before. Obviously, it was useful to have a public inquiry. Be glad that it didn't have teeth because it was politicized. Obviously, that, well, you can tell by the findings of that. So it is a political reason, not a security reason, and that is incorrect and not right. Suggests a level of arrogance by the government to say if your show more. If your movement, which is dissenting the government, starts to grow, that is a harm to the government. No, that is not the case. It means you are wrong and you need to check your actions, not the protesters. Anyway, big long thread. Financial measures of freezing and seizing bank accounts were particularly chilling for so many reasons and greatly benefited the ruling party because Canadians were afraid to donate money to essentially their political opponents. That is just unbelievable that, yeah, they went after people for donations. And these were political donations, and that's protected under the charter as freedom of speech. They're talking now about the financial institutions basically became the police without a court order, just a list provided by the RCMP. This is one of the most wild things to come out of the inquiry. The banks are not police enforcers. And well, it just goes on. And again, links in the description. You can check out the thread about all of this and what's been going on in this inquiry so far. But yeah, so what's come out of this as well? We also have a woman who was arrested in Ottawa after the invocation of the Emergencies Act and charged with mischief with obstructing an officer in the execution of their work with disobeying lawful order, has been acquitted of all charges. So as we keep hearing, and we heard about this during the inquiry, that there were so many arrests. Well, there were a lot of arrests, but none of the charges ever stuck. So there were a few people that took plea deals to get out of it. So those would have been charges that stuck because they were pleading to just get out of the lawfare, as they've been calling it, where the actual process is the punishment, especially when it's trumped up charges that don't ever actually end up sticking. So when you end up being acquitted for these charges, of course, there's no recourse to the lawfare. You can't get your time back. You can't get your money back that you spent on court costs. And of course, it's all paid for by the tax dollar when they're doing it from the government perspective. So this is the ongoing issue of the court challenge of the Emergencies Act. And well, let's hope that we see better results than we did from the inquiry itself. The inquiry was a good exercise because a lot of people were paying attention to it, and they saw just how horribly the system is working in Canada at the moment. So it was not an exercise in futility, because it did bring a lot of good information to light for the public to see and possibly sway opinions in the future. And public opinion definitely ends up swaying policy in the future. So anyway, leave a comment in the comment section down below. Let me know what you think of this whole situation, and we'll see you in the next one. Keep on trucking.